In this video, I'll be explaining the Child Inclusive Mediation process and how it can assist to lead child-focused negotiations and keep your matter out of court. Child Inclusive Mediation might be appropriate for your matter if you have a child or children that are around the age of 5 or older. Following separation, it's very common for children to tell each parent and each household things that they believe that parent or household want to hear. With child inclusive mediation, each child will have the opportunity to meet with the child consultant privately and separately and to discuss their views and their experience of separation with an independent, highly trained professional. This can help clarify issues if the children are telling each parent or each household things that they believe each parent or household want to hear, or if they're just generally telling each parent different things. Often when children meet and speak with the child consultant, that might be the first time that they've actually talked to an independent third person who is not related to them regarding their experience of separation and the parenting arrangements that they might prefer. The child consultant will meet with each child separately and privately before the mediation takes place. The child consultant will speak with each child regarding their experience of separation, their relationship with each parent, their extended family. They'll discuss a range of topics and issues with the child to ascertain each child's experience of separation, any issues that might be relevant to discuss at mediation, and any views the children might express in relation to their preferred parenting arrangements. It's really important for me to clarify that the children do not come to mediation and they do not engage in negotiations at mediation with the parents. That would be extremely stressful for the children and inappropriate. Instead, what happens is the parents attend mediation with the mediator and the child consultant attends mediation. The child consultant usually commences mediation by giving their summary of each child's disclosures in relation to their experience of separation, any issues that they might raise, and any views each child might raise in relation to parenting arrangements that they might prefer. This often kicks mediation off to a child-focused start. Once the consultant has finished with their summary and their discussion in relation to the children's experience of separation, any views the children might have in relation to parenting arrangements, and any other relevant issues, we then move on to negotiate parenting arrangements with the mediator and the parents. So, how can child inclusive mediation possibly save you the time, money, and stress of going to court? Well, if you end up in court, usually what happens before an interim hearing regarding parenting orders is that a child court expert will be engaged to meet with the parties, talk with the children, and then prepare a report and recommendations in relation to interim orders. Then, if the matter doesn't settle and it proceeds all the way to a final hearing, it's common for a family consultant to be engaged to review all of the material and all of the evidence on the court record, to meet with each parent, the child or children, and then again to prepare a more comprehensive report and a summary of all of the evidence, and then to provide recommendations to the court in relation to appropriate final orders. Essentially, the child inclusive mediation process is similar to going to court and obtaining these child court expert or family consultant reports, because you have the benefit of a child expert, who is usually a psychologist or a social worker, meeting with each child and then providing their view in relation to child-focused and appropriate parenting arrangements. So you can skip the time, stress, and money of going to court and have the benefit of engaging one of these experts prior to court proceedings at mediation. And this is a significant benefit. And in my experience, it can help parents lead child-focused negotiations and learn what the children might say to an independent expert without the hassle of going to court. Everything that is said or done at child inclusive mediation is to be kept confidential and it's inadmissible in court, subject to some very limited exceptions, which we'll discuss during our intake process. So there is undoubtedly huge benefit to hearing what your child or children might say to an independent child court expert or child consultant prior to paying all that money and having all the stress of proceeding to court. And so at Child Inclusive Mediation, you can hear your child or children's express views and any issues that they might have in relation to your home or your ex-partner's home and their experience of separation in a private, confidential setting. And those comments and their disclosures can't later be used against you in court. If you've got questions regarding the Child Inclusive Mediation process, let me know in the comment section down below. My name's Catherine, I'm a lawyer and I'm also a mediator practicing in Australia. My details will be in the description box down below.